Friday group meeting. Speaker is our beloved senior affectionate Mr. R.Basant, senior advocate, is retired from Kerala High Court. The topic is demystification of the concept of proof behind the shadow of a reasonable doubt. Sir, earlier we have 45 minutes your speech, 15 minutes question answer, sir. So I would like to you express something. I want if you share that, please. Maybe. Yeah. Sir want to share some experience of the Friday group. It's in the flight or something.
It's just incidental.
Incidental.
I'm so happy to be back with you. I've been coming here off and on. So happy to be with this group. And as I always start by saying, my most hearty felicitations to Sheshu. I have to repeat that every time. Because to keep an academic group like this growing and then on and on is really difficult. And I think he's not the type who's very populist. I can see some of you being struck off from the Friday group if you put something which is not there. Discipline, commitment, something which you all have to learn from. If this has been going on, I think it's only because of him. I was telling him I had a very, very pleasant experience last fortnight. I was traveling. And then when somebody was sitting near me, he looked at me and said, he started talking to me about my views on the DNA test. I was a little surprised. I said, I have not seen you. Are you in the Friday group? He said, no, I've been seeing that in the YouTube. Well, how popular he has become. I didn't know the person, he didn't know me also, probably he knew me also, but then he was talking to me, and I was looking at him and I said, are you a lawyer do you no sir, I don't know, but I'm interested in the topics which you discussed. So from your earlier topic on that, we had that, no, not the DNA, what is that, the triple talaq, and from that I've been listening to you, and the reach has become so much more. So I really, really congratulate you on that.
Sir, as on date, 64,500 people are viewers for Friday group in YouTube channel.
Wow.
So I myself very surprised. That means it went to masses, the average lawyer, average conscious citizen.
We are not surprised.
we are all happy that it is growing. That's it. Right? Not surprised, but very happy to see it growing. Okay, now we will start now.
Please.
Yeah. Okay. Well, last a couple of meetings back, a Friday the next day, Monday when I came, I was inquiring about what happened on Friday. I could not come on that day. So Mr. Vijay Panjwani, you know him, no? He's not here today, no? No, he was telling me it was very good, but then he said, why are you always selecting topics favorable to the accused alone? Why are you not choosing some topic which will be in the interest of social security also? That set me thinking, and I thought maybe it's a good idea for us to have a topic which is not always taking one side. No, generally, not that we try to advocate one side, but then generally it boils down to sometimes we target the group as a practicing criminal lawyer on the defense side and do it. And so I thought, why not we have a topic which is slightly different, and it will have the view from the other angle. That's the top that explains the choice of the topic today. I must thank Mr. Panjwani, who is not here. He very alertly listens to what's happening, and then he tells me, he makes suggestions which are very useful. That's what I feel about it. Now, as soon as I gave the topic, I don't know that person, but in your group, somebody came out with a question. What do you mean by this? What do you mean by demystification of the concept of proof beyond reasonable doubt? He said, I have not understood. Please explain. I don't know whether that young boy is here today, but I said I'll explain it to you when the time comes. Well, I remember in the school I had a teacher who said, before you start discussion on any topic, define the terms. Define the terms and then only get on to an argument. Therefore, I think I'm duty bound to say what I mean by the expression demystification of the concept of burden of proof, or proof beyond reasonable doubt. I looked into the dictionary. See, demystification has a meaning. Demystification has a meaning. Demystification, in short, for the context, there are certain ideas which are obscure, not very common. There are certain ideas which appear to be magical. There are some ideas which appear to be mysterious. Now, the concept of proof beyond reasonable doubt, proof beyond the shadow of a reasonable doubt as somewhere, is a mystery of the Indian law. I think there is a lot of obscurity about it, that people look at it with awe, and they are not, what you do not understand completely, you are a little overawed and you are not able to. And that is why I thought this topic may be useful. Now, demystification only means, at the end of the day, clarification of an unfamiliar concept. That's all that I meant. It's not meant to say take sides as to whether this is necessary or not. I thought the idea of proof beyond the shadow of a reasonable doubt deserves to be explained and understood, clarified. That's my purpose. Because I always, I've told you that many times here, my life as a lawyer, I've been in the system for about 50 years now, 49 years to be exact. First 3 years as a law student, next 15 years as a practicing lawyer at the lower court, the district court level, and the next 15 years as a judge as a session judge, direct recruitee session judge, the next 10 years as a judge of the Kerala High Court, and the last 7 years with you here as a senior counsel. So I have a long the experience, and I always keep saying, any fool with so much of experience must have understood something, and that's all that I try to claim and share with you. Now, this concept of proof beyond the shadow of a reasonable doubt, I find is very, very unfamiliar even with the grassroots operators of the law. What exactly do we mean by the expression of proof beyond the shadow of a reasonable doubt? There is always the feeling there's something mystical about it, something magical about it, some obscurity around it, and therefore it's important that practitioners try to understand what exactly is this concept. And that is my humble attempt today would be only to clarify that concept. Demystification is a big word because I wanted to convey that the mystery around that concept is really non-existent. It's a concept which is capable of easy understanding. There's no mystery about it. Clarify that concept is what I intend to do. I have a very short time. 45 minutes would be too little a time to really tackle with this. Now, if anyone is interested in my thoughts on the subject in more detail after hearing me, I'll give you 2 citations which in the Kerala High Court when I delivered 2 judgments where these concepts I've tried to deal with in detail. If you want, you read them. It's very, very immodest to speak more about one's own judgment, and therefore I don't want to do that. If you are interested, you go through that and find out. There are two judgments. It is Jose versus State, some V. Jose versus State, 2010 SCC, online, Kerala, 346. I'll repeat. Jose versus State, 2010 SCC, online, Kerala, 346. And the next is, there were some doubts raised on that, and therefore the next judgment that was clarified, and that is Krishna versus State, right? 2012 SCC, online, Kerala, 31617.
Sir, please repeat.
I'll repeat. First one, 2010 SCC, online, Kerala, 346. Next is Krishna, that is 2012 SCC, online, Kerala, 31617. Whatever I am trying to tell you, you will find has been dealt with in greater detail. In case for shortage of time I am not able to explain any concept clearly, kindly go through that. Well, all of you know that before a case, facts have to be proved, right? The one who seeks relief from the court will have to prove facts which he thinks are necessary to be proved to get the relief that he wants. Facts have to be proved. Now the other side, the adversary, will have to prove facts to justify that he is not liable. He doesn't have to concede the relief or claim something in return. Either way, both sides have to prove facts. Right? It's easy to say prove facts, but then how do you find out what a fact is proved or not? Your lay common sense will tell you that certain facts are proved by certain evidence. But how do you find it out? Where do you find the expatiation of the concept of proof? I'm not putting questions, but can someone of you help me to say, where do you find the meaning of proof? Evidence Act. Evidence Act is a big volume. Now, where in the Evidence Act do you get it? Where in the Evidence Act will you get it? Now, you know, the Evidence Act speaks of facts, it speaks of relevant facts, it speaks of facts in issue, in turn, though so the term is not defined, it speaks of primary facts, it speaks of inferential facts, a lot of facts. Now, where do you get, if you look to find out, how do I know whether something is proved or not? Where do I look for that? Which part of the Evidence Act will you look into to find out how is a fact proved or not?
Admissibility of evidence.
Admissibility of evidence is only what can come in.
Relevant process.
Relevant, yes, no, relevant facts alone can be taken. See, you cannot take in any fact which is not admissible, which is not relevant, but all that put into the hot spot, in the crucible, how do you find out whether something is proved or not?
There should not be any reasonable doubt.
Well, maybe that's one way of looking at it, but not what I am asking you. I am asking you which provision in the Indian Evidence Act will tell you whether a fact is proved or not. What is the test? What is the litmus test by which you will find out whether the material before me is sufficient to hold that a fact is proved or not? I keep repeating that this provision that I am going to refer to is the Bible of a court of facts. Is the Bible of a court of facts because that is the very fundamental test to decide whether a fact is proved or not. Now, I invite your attention to Section 3. You must all know. When I say that, every one of you will know that. No? Section 3 of the Evidence Act defines what is proved, what is disproved, and what is not proved. There are three expressions in the Evidence Act, Section 3, in the definition clause, which tells you how can you find out whether a fact is proved. The other part of it is when can you find out, how can you find out whether a fact is disproved. Now, proved is one thing, disproved is another thing. All the remaining would be not proved. And therefore, to find out, next time somebody asks you, how do you find out, what is the test, you say, Section 3 of the Evidence Act, which defines proved, disproved, and whatever remains is proved. You know me normally I don't want to take you through the sections or the precedents specifically, but as I told you, this is so fundamental that I don't want any practicing lawyer ever to miss it. Therefore, I would like you to, we will together read Section 3 to find out what are the sweep of these expressions: proved, disproved, and not proved. I take you to that. Proved. It defines what is proved. Now, it's interesting. See, in 1872, James Stephen defined these expressions. It's very interesting. We have not been able to touch it really. The beauty of the definitions you have got to see to find out. What an analytical forensic mind he had to define terms. Today we speak as soon as whether it is proved, you say true. A fact is true. A fact is proved if it is true. He does not use the word true at all in the definition. Now I'll read to you the definition. It says, a fact is said to be proved when, after considering the matters before it, underline, matters before it, not only the evidence before it, yet the matters before it, the court either believes it to exist. The court evidently the judge, single judge or the plural benches, the court believes in its existence or considers its existence so probable that a prudent person, under the circumstances of the particular case, ought to act upon the supposition that it exists. Right? This is the definition of the expression proved. Before I go further, I'll take you to disproved also. Disproved says, the next definition is disproved. A fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist. Earlier definition was it exists. Now it says the court either believes that it does not exist or considers its existence so improbable, considers its non-existence so probable that a prudent person ought to act on the supposition that the fact does not exist. You understand? Now, one side you have a definition of proved, which says the court may believe in its existence or the court may consider its existence so probable that the prudent person ought to act on the supposition that it exists. Now, when it comes to disproved, it says, same definition, the difference is only this, a fact is said to be disproved. When the court, on considering the matters before it, believes in its non-existence or considers its non-existence so probable that a prudent person ought to proceed on the supposition that it exists. This is the definition of proved and disproved. Now let me ask you, what is not proved? Well, all that is not proved does not come within the definition of proved is not disproved. What does not fall within not proved may fall either within disproved or not proved. And therefore, section says a fact is said to be not proved when it is neither proved nor disproved. Right? Fundamental. And never forget this. Every judge of facts, I go to the judicial academies and deal with the judges and the trial judges. I tell them, learn this by heart. Every day when you have a problem, please repeat this. In your mind you repeat this so you will understand what is meant by the expression proved, what is disproved and what is not proved. Note, please be good enough to note that all that does not come within proved is not proved. It must be not fall within disproved, it must not fall within proved, then only it is not proved. Right? There is a controversy. I will not detain you with that controversy in this discussion. You know why? Because we don't have the time for it. There is a huge dispute as to whether the expressions to that is where the court believes in its existence or the court considers its existence so probable that a prudent person ought to proceed on the supposition that it exists. It means the same. Because a judge is also a prudent person. At least we assume it to be so. Fictionally, I as a judge is also a prudent person. And therefore, what is covered by the former expression which does not come within the latter expression, I am not taking you through that today. Maybe some other occasion we will do that. Today, for the purpose of our discussion today, I would want you only to know, because I'll just indicate that a judge, it is always said, has trained intuitions. What they call the trained intuitions are there. It is my pet theme when it says that what believes in its existence, it must be the court, it only belongs to the realm of the court. And then the other is find out whether a prudent person ought to proceed on the supposition that it exists because it is so probable. Right? Only for this purpose I am mentioning that, otherwise I am only... You all know that a judge has no magic wand. He has no magic wand. As a judge, I was a trial judge, for 14 years I was a session judge. I've always found, have you all read about H.G. Wells' Time Machine? H.G. Wells as a scientific fiction writer, he spoke of a time machine. You know what a time machine is? I can sit in my time machine chair and push it forward. It will forward Trigal at Nani. I will go front to see what's happening there. I can push it backwards. I can go there. So in geography and chronometry, time, I can travel wherever I want. Now I thought as a trial judge, whenever one of the supposing God appears before you and says, "Oh, Mr. Basant, what do you want?" I said, "Please give me a time machine. I'm spending so much of time to find out what is probable, what is believable. If you give me the time machine, I will travel to that spot, see for myself what had happened, and then I will be very, very convinced. No place of a doubt there. You see, but then no God offered me that, and then, today's judge also has to go with the definition of proved and disproved. Now, any judge can decide matters only on the touchstone of probability. There is no other way a person can decide. It's only on the touchstone of probability that any judge at any point of time can decide a matter. So probabilities is the litmus test to decide, for a judge to decide whether a fact is proved, disproved or not proved. The only thing that helps you is the probabilities. Because I was not there to see it, and if I had seen it, I would not be a judge. See, no man can be, the topic is very live today, isn't it? Can a man be a judge of his own cause is very live today, and therefore you will all easily understand that concept today. And therefore, the only way a person can decide is by deciding, by testing the material on the touchstone of probabilities. Okay? Now, this definition of proved, not proved and disproved, I'd like to take a pictorial representation of what it is. We don't have a board, therefore well, if we were to try to make a pictorial geometrical representation of this, because there are two end points are known. What is that? Absolute certainty about the existence of a fact. On the other side, you have absolute certainty about the non-existence of a fact. See, in between these 2 points lies the satisfaction of a court. It's not a 1-point satisfaction. You cannot say it's 1 point. It's a range of satisfaction. It starts from absolute certainty of existence to absolute certainty of non-existence. And therefore, the 3 definitions that we spoke of must fall within 1 point in this line of satisfaction of the court. Therefore, I am trying to draw that line. Supposing I draw a line like this. Point A, I will say, is the point of absolute certainty, right? It's where the judge is absolutely certain. Well, this is a fiction. I have never come across any judge being able to say something is absolutely certain. You must have the intellectual humility always to feel that maybe I am wrong. And therefore, absolute certainty does not belong to the realm of ordinary mortals. Be that as it may, fictionally this would be a point of absolute certainty. Go to the other end, I will say it's a point of absolute certainty about non-existence. So this line of satisfaction is between point of absolute certainty of existence to point of absolute certainty about non-existence. Now this line I will further divide into 2. See, I'll put it at B and say this is the sector proved. On this side you have the sector proved. What falls within A and B points will be proved. Now I'll mark a point here C and I'll say what falls between C and D will be disproved. Right? We read the definition. That's why I read the definition to start with. So AB will be proved, CB will be disproved, and BC will be not proved. So I'll write that this is proved, this is not proved, and this is disproved. Right? Like 3 sectors you have found. This is what, according to me, this is what the if I were to try to make that expression pictorially, this is what happens. At the end of the day, the judge looks at the facts, looks at all matters before him and tries to find out, does it fall within AB, does it fall within CD, or does it fall within BC? Right. In order that a fact is said to be proved, where should it fall, tell me? AB only? Yes. Correct? Yes. If only it falls within AB, you can call it proved. Supposing it is within BC, what will you say?
Not proved.
It's not proved. If it is other side, CD, it is disproved. And therefore, in any fact for that matter, the judge tries to find out whether what is talked about today falls within AB or not. That is the endeavor of a trial judge. A judge of facts is trying to find out if it is within AB, yes, proved. If it is outside AB, if it is within BC, it is not proved. If it is in CD, of course it is disproved, the worst case. So that the point that I want trying to make is, we are always trying to find out whether the given set of facts, all matters before the court considered, where will it fall? Expression proved is, it has to fall within AB. If it falls within BC, you can't say it is proved, because it is not proved. By definition it is not proved. And the other one, of course, it doesn't come up. I want some water. Okay. So the whole effort is to find out whether it is within AB or not. That is what the court, what we always try to find out. Sorry, old throats. Old throats do not work properly. Okay. Now, hello. Okay. Then, see, bear this in mind. Any case for that matter, if a plaintiff or a complainant is to succeed, he must prove his facts. To prove his facts, the case must fall within AB, I repeat, not within BC or CD, right? So the effort is to find out whether it falls within this or not. Now, if that is so, my next question is, what is the test that you adopt in a civil case to decide whether this falls within this or not? You know. We have read section 3 now. Section 3 does not make a distinction between a civil case and a criminal case, right? We have said this, we have read this now. It does not make any distinction between a civil case and a criminal case. But today in court, when you sit down and want to decide, what do you say? How do you prove a case how do you hold that a fact is proved in a civil case? When it is proved on balance of probabilities, right? That's what we always say. In a civil case, we say it is decided on balance of probabilities. In a criminal case, we say it is beyond reasonable doubt. Or you exaggerate that and say beyond the shadow of a reasonable doubt. The mystery that I spoke of, right? So that what I'm wanting you to ask yourself is, under the statute, under the Evidence Act, definition of section 3, is there a distinction between proof in a civil case and proof in a criminal case? In the definition, going by the definition, the same definition of proved, disproved and not proved is applicable for the civil case and the criminal case or whatever case it is. The same definition. Statutorily, there is no difference. But we all know, we have been told, taught, and we are all convinced that civil case is decided on the touchstone of probabilities, whereas a criminal case is decided on proof beyond reasonable doubt. Well, this is what I wanted to know. If the definition is the same for the civil case and the criminal case, any precedent cannot go beyond the statute. And therefore, we ought to find out, how did this difference come at all? See, if the same definition is to apply for a civil case and a criminal case, how are we saying that the concept of proof today, everyone asks the young law student, he will also say proof beyond reasonable doubt in one case and proof on balance of probabilities. And therefore it is as though probabilities is not available for a criminal judge. No, and this is the mystery that I am trying to resolve. It's not as though a criminal case can be decided otherwise than on probabilities. A civil case, as also a criminal case, will have to be decided on the touchstone of probabilities. Right? If a judge has seen, he is not the judge. If he has seen the incident, then he is not the judge, because evidently he can't be a judge in a matter which he has seen, and therefore he not be. And therefore both are decided only on the touchstone of probabilities. I would like you to introspect, ask yourself the question, how did this difference come? It cannot be against the statute. Well, no, at least fictionally, there can be no precedent which runs against the statute. So we do find sometimes, that's a different matter altogether. But ordinarily, as per law, you cannot have an interpretation which is different from the statute. And proved, I repeat, has been defined by the same standards, both in a civil case and a criminal case under section 3 of the Evidence Act. Now my question to you is, please try to find out, analyze how the difference came. Difference is there today, I have no doubt about it. I will not enter a controversy on that. Today we all know a higher degree of proof is required in a criminal case. At least that much, call it the romantic expression of proof beyond the shadow of a reasonable doubt, etc. But today we are convinced that there must be a higher degree of proof in a criminal case as distinguished from a civil case. How is this possible in view of the common definition?
Consequences are imprisonment.
Yes, sir. Very, very correct. No, that's what I was about to. Because in life as in law, the situation is important. That is why you will find, I read to you section 3. Section 3 adopts the standards of a prudent person. Well, in life a prudent person would insist on higher degree of proof depending on the consequences. Like a simple example, your children misbehave, right? Your children misbehave. He uses bad words against another. You call him. You don't bother for more detailed evidence or that, and then you say, what is this? You should not do this, right? But in the next case, supposing you come to know that he had abused his teacher, then you go to the teacher and find out, did he do this? So you satisfy yourself better before you come to that conclusion, and if that is proved, you may give him a spank. See the difference. Sir said, depending on the consequences, a prudent person would insist on a higher degree of proof. This would go on. This would go more and more. Supposing your child or grandchild comes and then there's a complaint against him that he stole something from the neighbor's bag, you will definitely go into that in detail. You will open your son's bag, find out that stolen thing is here, and when you recover that only you will be very certain. Otherwise you will not make an allegation against him. Otherwise you will not spank him. You will not send him to school for 2 days to discipline him. So in life as in law, the consequence decides the degree of satisfaction that I must get. Right? A prudent person, I am talking about a prudent person. A prudent person would insist on a higher degree of proof depending upon the consequences. The consequence is grave, you will look. And what is the consequence between a civil case and a criminal case? In a civil case, restoration, compensation, etc. are the remedies available. So far as a criminal case is concerned, what is the consequence? It could be deprivation of life, liberty, or property, right? Fine, property, life sentence, term sentence is liberty, life sentence, and death in the last case. So, in a criminal case, when you have to find a person guilty, you are wanting a higher degree of satisfaction because of the consequence. A consequence of deprivation of life, liberty, or property. This is not alien to the definition under section 3. Section 3 is elastic enough that this concept inheres in the definition itself. That is why they said a prudent person standards are introduced. See, the distinction between proof in a criminal case and a proof in a civil case arises from this prudent person concepts or a prudent person's insistence on the degree of proof that will be required. It's not something alien to the section. The section itself provides elasticity so that in a criminal case, the standard can be different from that in a civil case. So that please do not think that there is something mystic about it, some mysterious about it, something obscure about it. It's something that comes from the definition itself. It is something that comes from life itself. That's why I wanted to take the example of your children. No, that's what all of us, every day we have that example. And therefore, depending on the consequences, you insist on a higher degree of proof. Well, this concept has been explained very beautifully in a couple of decisions. I'll just mention to you that, and maybe one short paragraph I'll read. The English decision, both by Lord Denning says, Lord Denning in decision says, it is not as though the distinction is between a civil case and a criminal case. Even within a civil case, there can be varying degrees of proof. His Lordship refers to the concept and allegation and proof of fraud. He says, any court will insist on a higher degree of proof in a matter of fraud than the evidence which would ordinarily insist on other cases. Similarly, he says on graver felony, on graver instances of crime, you may insist on a greater amount of proof than. I'll just tell you that, See, in the Indian Supreme Court has said, to decide whether a death sentence should be awarded or not, even after being satisfied that the matter has been proved beyond doubt, you must further insist that there is no residual doubt. You have seen the decision? Tell me the Devarma decision. I'll tell you that decision, that also you note and read it later. Ashok Devarma decision, I'll give you that citation. I have my Manu with me so that he's helping me out on this. Now this you can take off. Strength.
He's the only tranquilizer, sir.
Okay, you please read this decision.
Yes.
2014 4 SCC 747. See, this is between absolute certainty and proof beyond reasonable doubt. Sorry, I should have said Ashok Devarma 2014 4 SCC 747. In case any one of you does not get it, you can later on come with him and then get it. Okay. Ashok Devarma. This speaks of a residual doubt on the final, ultimate, sublime, highest level of choice between life and death and punishment. There they say, it may have been proved. It may have been proved beyond doubt. It may have been proved beyond reasonable doubt. Still, it is a little short of absolute certainty. And in a case where you have a residual doubt, do not impose the death sentence. Well, I'm only trying to point out to you that the consequence would call the shots in the extent of proof required. Well, even a residual doubt may lead to not imposing a death sentence. And therefore, consequence is important to find out the extent of proof required. Therefore, what I want to tell you is, please note that it is not, the distinction is not between civil case and a criminal case. Within a civil case itself, there could be varying degrees. Within a criminal case itself, there could be varying degrees. Again, dependent on the consequences. And that is exactly what Section 3 says. There is no magic of proof in a criminal case. Again, we are only trying to apply, understand, digest and apply Section 3 only. There is no mysticism about it. We are saying that the concept of proof beyond reasonable doubt, as we today understand it, is also only an offshoot of the definition of the expression proved, not proved and disproved in the Evidence Act. The three levels of satisfaction which I showed you, A, B, B, C, D, C, D. It's only that. So it's not as though it's something strange dropped from heavens. See, it's very interesting. See, even before the Evidence Act was formulated, these concepts were there in all refined systems of criminal jurisprudence. Now, 1878 only, even before that, English common law said there must be proof beyond reasonable doubt, proof beyond doubt in a criminal case. Before a person is deprived of life and liberty, there must be proof beyond doubt. Today it is part of human right. Forget about the statutory right or the constitutional right. It is part of human right today that every criminal can be convicted or deprived of life and liberty only if there is proof beyond doubt in a fair trial held. So that this proof of beyond doubt which we talk of, which according to me is only an implementation of the statutory philosophy of definition of proved in Section 3, stems from Section 3 itself. It's not something alien to the statute. It's not alien to the statutory provision. Now the question comes, then it was always enough to say it should have been proved. Why did you import this? See, because proved includes the prudent man standards of differentiating, and therefore why? Now that is where I want. No, before that, one more. I told you about two English decisions by Justice Denning. I'll just take you through that. I'll just read the important lines in that so that you will understand. Bater versus Bater is an English decision in 1950, All England Reporter 458. 1950, All England Reporter 458. I'll just read a few lines, they're beautiful. They are poetic, they are beautiful, we should understand that. It is true, this is what Lord Justice Jennings says, it is true that our law, there is a higher standard of proof in criminal cases than in civil cases. But this is subject to the qualification that there is no absolute standard in either case. In criminal cases, the charge must be proved beyond reasonable doubt, but there may be degrees of proof within that standard. Many great judges have said that in proportion as the crime is enormous, so ought the proof to be clear. So also in civil cases, the case may be proved by a preponderance of probability, but there may be degrees of probability within that standard also. The degree depends on the subject matter. A civil court, when considering a charge of fraud, will naturally require a higher degree of probability than that which it would require while considering whether negligence has been established. It does not adopt so high a degree as the criminal code, even when it is considering a charge of a criminal nature, but still it does require a degree of probability which is commensurate with the occasion. So that's the point that I wanted to make. Okay?
Thank you.
Okay, so thank you so much. Later in the decision he further said, I'm not reading the entire thing, we don't have the time also. It does not say that the degree of probability must be as high as 99% or as low as 51%. It doesn't say. The degree required must depend on the mind of the reasonable and just man, the prudent man, who is considering the particular subject matter. I'll leave it there, Now I would also want you to read another judgment. Just read that.
Part 2 also, subjective or conveyance.
Yeah.
This topic, if you want to continue, part 2
Okay,
also.
okay.
sir.
It's time now.
Purely.
Yeah.
No, you have time.
Yeah.
It was a long time.
There is another decision I want you to read that. Miller versus Minister of Pensions. That is 1947 to All England Report 372. Miller versus Minister of Pensions. That is what I get as a judge. Miller versus Minister of Pensions 1947 to All England Reporter 372. You all got it?
Yes.
Okay, just one line from that I'll read, because it's again on the topic. What is the topic that you're trying to... The definition inheres this varying degrees of probability. It's not something different in a criminal case. It is only a one of degree and not species. The proof is the same. The definition of proof is the same. It's only it's not, the difference lies not in the species of proof, but only in the degree of proof, right? That is what this passage says. The degree is well settled. It need not reach certainty, but it must carry a high degree of probability. Proof beyond reasonable doubt does not mean proof beyond the shadow of a reasonable doubt. I'll come to that a little later. The law would fail to protect the community if it admitted fanciful possibilities to deflect the course of justice. If the evidence is so strong against a man as to leave only remote possibility in his favor, which can be dismissed with sentence, of course, it is possible, but not in the least probable, the case is proved beyond reasonable doubt. Right? Now we must find out how we were led to this error, to think that there is a difference in species. Every child in law in this country would think that the two are mystically different. One is probability, the other is proof beyond reasonable doubt, and so there is essentially a difference between the two. The Malimat Commission, when it was called upon, deals with that question and says how this has come around. It says, in England, there was a jury. All the trials were jury trials. Today we are not conversant with the jury trial. Even in my days, there was no jury trial. But we have heard of it. We have heard of a jury trial. At least in cities like the metropolitan cities like Mumbai, Calcutta, I think there were juries. But today, whole of India has given up.
He looks like one of the jury.
Right.
Similar to Lord William Denning.
Yeah. See, the point that I'm trying to make is, how does this concept of proof and prove beyond doubt, prove beyond reasonable doubt, and prove beyond the shadow of reasonable doubt emanate from the common definition of proved, in both in a civil case and a criminal case. Now that is where it is said, you know, those of you who have read about the Perry Mason, you must have, in my days we used to read a lot of Perry Mason, and then that would tell you what a jury trial is. In a jury trial, we have selected 11 or 13 persons, depending upon the 13 persons who will be representatives of the ordinary prudent person. They are just ordinary prudent person. They are not men of law. They are just a factory worker may be there, a school teacher may be there, an advocate clerk may be there. Depending upon the respectability of the person, integrity of the person, he is chosen and he is obliged to serve as a member of the jury. Now he is not trained in law. He does not understand the definition of section 3. The judge tells him, these are the facts which you have to take into account. See, inadmissible facts will be excluded by him. The judge will, in the ultimate address to the jury, the judge will tell them, oh jury, please take note of these circumstances. Don't take note of other circumstances which have been suggested to you. These are the circumstances on which you must take into consideration. And considering all this, tell me as a prudent person whether this fact is proved or not. They are living samples of the prudent person. In today's terminology, if you say you feed all data at one end, out comes the result whether the fact is proved or not. The jury is a machine today, if you can compare. The judge would ensure that all relevant facts, admissible facts are fed to the jury, and the jury will come out with a verdict, found guilty. Right? Or found not guilty. See, this was the type of jury that was deciding disputed questions of fact in a jury trial. Now the judges were worried about liberty, freedom of individual, so they had to caution the jury. The jury may decide on emotion. So they have to tell the jury repeatedly, oh jury, don't decide on other things, decide on the material that I have fed you and decide as reasonably as a prudent person whether a fact is proved or not. That is your business. But make sure that this is a criminal case, the consequence is more disastrous for the person, and therefore be sure that you adopt that higher degree of proof when you give a verdict in a criminal case as distinguished from a civil case. And that is why you will find here the judges started addressing the jury. See, today, as per definition, when you are talking to a law person, I will tell you, please make sure that the definition is complied with. The fact must be proved in accordance with the definition, which is elastic enough to take into account a criminal case also. So, a man versed in law today, I need only tell you that please make sure whether a fact is proved or not. In a civil case, you know how it is proved. In a criminal case, you know how it is proved. That I need only tell you, if I were to talk to a magistrate today, I will say, follow section 3 and come to a finding. But when it is the jury, lay jury, untrained jury, the judge has to caution the jury. And then so the judge said, please make sure that a fact is proved. And then he found the jury is not absorbing it. So he said, please make sure in a criminal case a fact is proved beyond doubt. Right? He was only impressing upon, the judge was only impressing upon the jury the need to be more cautious considering the consequences when you give a verdict in a criminal case. And therefore you said, please take that board. See, today you need only say, make sure that it falls within proved in a criminal trial. Right? That is enough. But the jury would not understand that. You are not trained in law. So the judge went out of his way and said, make sure that there is proof beyond doubt. Well, after some time, judges found, even after this caution, the jury is not correctly oriented. So the judges had to say, make sure that there is proof beyond, not doubt, beyond reasonable doubt. See, this is all caution administered to the jury. Jury who is not competent, lay jury had to be addressed. This Madhavan Commission refers to this. Yeah? And so it has to be, the jury has to be told, make sure that there is proof, that is enough, but you're not understanding it properly, so make sure that there is proof beyond doubt in a criminal case. Still you're not understanding, then I'm again repeating to you, please make sure that there is proof beyond reasonable doubt. Even then he was not understanding. I mean, correctly, he was not catching the soul of it, and therefore he said, make sure that there is no shadow of a reasonable doubt. See, the concept developed further and further, not because this definition was insufficient, but the ones who were to act as per the definition were not able to comprehend the two dimensions or the responsibility on them. Now I'll take you back, I'll conclude quickly. I'll take you back to this. Today, a fact is said to be proved if it comes within AB only. If you have a doubt, supposing you have a doubt, where will it come, tell me? If you have a doubt as to whether a fact is proved or not, where would it come? It can only come under BC, right? It can never come under AB. Can I say, the fact is proved, but I have a doubt?
Then it's
Can you say that? Can you say that?
No.
See, so that it is superfluous to say there must be proof beyond doubt. Because if only it is beyond doubt, it will come within AB. If it is with doubt, if doubt remains, it will come only within BC. And therefore, today's judge, you need not tell him that please insist on proof beyond doubt. It is enough if you say, insist that there is proof as required under law. Well, I'll take you to the next one. Now it says proof beyond doubt. Now we added the word beyond doubt. Even then the jury was not understanding, so the judge told the jury, make sure that there is beyond reasonable doubt. Now I asked myself, can I say, I have a doubt, but not very reasonable? Right? Can you say that?
No,
So
never.
you can say, yes, I have a doubt. Not very reasonable. See, only a doubt which is reasonable is a doubt. And therefore, in saying that insist on proof beyond reasonable doubt, you are only wanting the jury to realize that the judgment is to be rendered in a case where there is deprivation of life or liberty. So be careful, be cautious, do not be carried away by emotion. Right? You can see even here it happens sometimes. Now I stand up to argue a case and the judge starts by saying, oh, 4 murders. But emotions carry you sometimes. It should not. I am very emphatic that it should not. In a detached criminal trial or a criminal appeal, judge is not concerned with the nature of the crime, but he is concerned with the proof regarding the crime. And then it is not relevant at all to say, oh, there are 4 persons killed in this case. It doesn't alter the situation. The question is whether there is evidence to prove this man has committed this murder. And therefore, in order to tell the jury, repeatedly caution him, the court said, the judge addressed the jury and said, make sure that it is proved, 1. Make sure that it is proved beyond doubt. Then further and said, make sure that there is proof beyond reasonable doubt. Even then you are not understanding, the court said, make sure that there isn't a shadow of reasonable doubt also. I start from the shadow of it. If there is no object, can there be a shadow? Right? So in saying that there must be proof beyond the shadow of a reasonable doubt, what is really said is only that there is proof beyond reasonable doubt. Now in saying that there must be proof beyond reasonable doubt, what you are saying is there must be proof beyond doubt. As I told you, when there is no object, there is no shadow. When there is a doubt which is not reasonable, it is not doubt at all in law, and therefore that need not be said. And then proof beyond doubt. If there is a doubt, it will only fall under BC. It will not come under the here also. It will not come under AB at all, and therefore even that is not required. The caution administered to the jury have assumed mystical proportions, and even today we think that in a criminal case, it is a totally different ball game, different from assessment of probabilities. That is where there needs to be demystification or the concept of burden of proof in a criminal trial. Well, all that is said is, please insist that it is within this. Please insist that the evidence is within AB, and that is all. That is all. That is all that is insisted. But you must know that because of the consequences of deprivation of life and liberty, you cannot have, you have to insist on a higher degree of proof. Just as in a civil case there are varying degrees of proof, as Lord Denning said, between a negligence case and a case of fraud, there will be difference in degree. Likewise, between a criminal case and a civil case, there will be difference. Within a criminal case, there could be a residual doubt in a capital offence when you consider sentence. So that all that was intended to be done is that there should be only, and therefore I'm saying, see, in a civil case AB may be sufficient, but in a criminal case probably at the end of it I'll say B1. This BB1 is an area, a level of satisfaction where you may think that because of the consequences in a criminal case, I must insist on better proof. So it's not one of species, it's one of degree only. Now this BB1 goes out of the finding of proof in a criminal case because considering the consequences, the judge as an ordinary prudent person would insist on a higher degree of proof, and therefore the small sector BB1 may go out, and see, in a criminal case AB1 alone may be held as proved, whereas in a civil case maybe AB will entirely be held as proved. Now the whole confusion arose because this address to the jury was confused completely. Now you thought that proved means proved beyond doubt, thinking that even if there is a doubt, it will fall within proved. We incorrectly thought that proof beyond doubt would include a proof beyond an unreasonable doubt will also be included. Incorrect, because a doubt, in order to qualify to be a doubt, has got to be reasonable. That is also not it. Right? All these I would say, the insistence today must be only that the definition of proved in section 3 must be satisfied both in a civil case and a criminal case. But in a criminal case, slightly higher standards of proof would be required depending upon the consequences, as I told you already, as in life, so in law also. The prudent person in life insists, and that prudent person's standards have to be imported while appreciating evidence in a criminal case also. So at the end of the day, the theme is demystify. See, do not be carried away by thinking that there's a mystery in this. There is no mystery at all. What is only required today to a set of magistrates, if I were to give a lecture, I would say, please understand section 3 correctly. Depending on the consequences, a prudent person may insist on higher degree of proof. Do that and that alone. Forget about the terms of proof beyond doubt, beyond reasonable doubt, beyond the shadow of a reasonable doubt. All that in effect only means it must be proved in accordance with section 3, considering the consequences in a criminal case. Thank you very much. I don't think we have already gone very much beyond.
For example, we can start.
Can you wait. Thank you very much, sir. Very nicely explained. I mean, unexplainable, the way you have taken pains and other teachers like classroom and all. We are really listening. We are all grateful to you, sir. Let us give a standing ovation to sir. I mean, skill. Mr. Ashok Arora want to question, sir. Please.
Please.
Thank you very much.